For those of you who don't know me, again, Patrick MacQueen, I'm a real estate attorney here in town. Been doing this 17 or so years. Our firm handles all sorts of real estate litigation, all sorts of real estate transactional matters. And that includes what we're going to talk about today, which is rezoning projects, land use issues, lot splits, accessory uses, expanding utilities, expanding your rights, your bucket of rights that come along with a particular piece of property. We're going to go through the various 5 or so things you can do as an owner of land to improve the value of the land and hopefully make a whole bunch more money. And this should be helpful for some of you because some of you are helping your clients buy land or buy projects that need to be rezoned, or something has to happen to get additional land use permits so that the people can use, so that your clients can use the property as they want to. Before I jump into what that really means and how it might affect you and your clients, I do want to mention a couple of brief legal updates on the commercial side. We're seeing a whole heck of a lot more land purchases, which is great. They seem to be on the rise. Reminder to look into the status of zoning prior to purchasing. Reminder to obtain surveys, environmental due diligence, review title work, all of that stuff, or have your clients do that for sure. Because we've seen a couple of people goof up. They thought that they could buy land. They thought that a lot split or a rezone was automatic. It's not. Okay, so if you need a land purchase checklist for your clients, for yourselves, shoot me an email after this and we'll make sure we get that to you. Issue number 2, or kind of hot item number 2 in the commercial world that we're seeing, are commercial leases are finally starting to, new commercial leases are finally starting to get circulated and negotiated. And I want to mention the top 5 or 4 or 5 provisions that are being negotiated because these are unique right now. First is the non-disturbance and attornment agreement, the NDAs, or subordination non-disturbance and attornment agreements, NDAs, right? Tenants are now insisting on these because if a tenant does not have a subordination non-disturbance and attornment agreement or an NDA, the tenant may lose their investment into the leased space. And so those tenants are requesting that the landlords go to their lenders and get the NDA. So that's something that's coming up. We see that sometimes when tenants are on the fence about a lease or the market isn't as strong as it has been. So maybe that's what's going on, but we're seeing a lot of requests for NDAs. Second is that we're seeing a lot of cleaning provisions now being negotiated. Never before in a commercial lease did we really care about cleaning. And now we're seeing reps and warranties about cleaning. We're seeing the provision of basic cleaning and then sanitization and how that cost gets passed through. So that's a unique one. So NDAs, cleaning provisions are big now. The compliance with the laws provision. So in every commercial lease, most every commercial lease anyways, there's a section or provision that says, landlord and tenant agree to comply with the laws, right? Well, nobody ever thought the first thing about that prior to the pandemic. It was a boilerplate throwaway provision, right? The compliance with the laws section, though, in every lease allowed the landlords to open buildings for essential workers or essential tenants. It allowed the landlords to shut down their buildings and shut down the spaces altogether. Okay, if that language wasn't in the lease, some of these we'd be litigating a lot more of these leases at the moment. Okay, so that's the permission that was granted. That's the contractual provision that allowed the landlords to shut down the buildings or open up their buildings during the shutdown. The 4th key element, or the 4th key provision, is the force majeure provision, the act of God. Parties are now finally defining or indicating that a declaration of a pandemic or a declaration of a national emergency constitute an event of force majeure. And then they're actually addressing what happens next. Do I have an obligation to pay CAM charges? Do I still have to pay rent? Do I have to keep my lights on? What happens in these events? And the courts have been very specific thus far in the last year as to wanting the parties to be very clear as to what is supposed to happen. It's not an automatic event of default or automatic event of force majeure. It's something that needs to be in the contract in the first place. And then there needs to be something specific as to what happens if there is an event of force majeure and how we make that determination. So people are starting to negotiate that. The 5th thing is this use provision. Tenants are seeking to expand the permitted use under their lease. And so they want to be able to assign the lease to somebody else if their business isn't working, or they need to go home and work from home or work from remotely, and get somebody else in there, or to do some sort of pivoting of what it means to be a business in that space. And so those are the top 4 or 5 provisions that we're seeing. I just want to throw those out there because I know that a lot of you on this call actually do handle a lot of commercial leasing, and those are the key things that we're seeing being discussed and negotiated, and I think that's great. Now, onto the zoning stuff. Okay, what I'm seeing are pretty significant requests for zoning changes for the construction of more houses is really what it is, for the construction or rezoning of land to allow for the construction of multifamily houses, to allow for the construction of single family homes. We're seeing office buildings being converted into apartment complexes, retail areas being converted into townhomes. We're seeing farming and agricultural zoning designations being converted into multifamily projects. And so right now is pretty good time to strike if you're wanting to buy land or wanting to buy something that just doesn't work anymore and rezone it, okay? And so number one, we're seeing zoning related to housing is probably the big one. And in some cities right now, or in some counties, you're literally getting a rubber stamp, approved, move forward with your project, hurry up and do it, right? Because of the lack of housing. So zoning changes to allow for an expansion of single family homes or multifamily homes, very, very popular right now, very, very easy to get right now. And we're also seeing zoning changes to allow for accessory uses. And what that really means is if you're a restaurant, if you're a retailer, and you want to have a pickup area, a designated pickup area, or curbside dining or curbside pickup, and you want the signage that goes along with it, well, guess what? That may very well be against the zoning code. That may very well not be allowed under current zoning laws. And so we're seeing a lot of folks who have ongoing businesses that want to offer this stuff, retail or outdoor dining, curbside pickup, those types of things. They want to offer that on a more permanent basis. So there were some temporary solutions that Governor Ducey came out with, some of the other states came out with it, but people want to turn these into permanent rights. And it's not automatic. You don't automatically get to have outdoor dining space. You don't automatically get to have curbside pickup or curbside delivery. And so now folks are starting to petition for permanent rights for those things. And, you know, people ask me all the time, well, you know, I own this land. Why can't I just go and do this with my land? Why can't I just go and knock down the building and put up an apartment complex? Why can't I just knock down, change things? And why can't I just have this accessory use? It's not really bothering anything. It's my property. And the answer is, you know, is that zoning codes just don't allow for that. And that's the major impediment is the zoning provisions, okay? And when we're doing this zoning analysis, we're looking at zoning ordinances that have been out for many, many years. And most zoning ordinances indicate that if the use isn't specifically permitted or specifically addressed in the zoning code, you cannot do it. Okay, so somebody who comes to me and says, hey, I want to change this raw land into an apartment complex, the zoning code, unless the zoning code says you can do that, you cannot do it. It has to be very specific and particular. And most codes go to great lengths to define what specifically can be done or what specifically can happen in an area, restaurants and agricultural land and multifamily housing. And if they don't say that these are permitted uses or permitted ancillary uses with what you're doing, you cannot do it, okay? Now, however, due to the pandemic and due to this housing issue, we're starting to see some relaxation of zoning, a relaxation of zoning conditions, and cities and municipalities more willing to provide zoning changes. So now, again, is probably a good time to start. And there was a reason for the prohibition, right? Public health, public safety, the prohibition on doing whatever you want. Public health, public safety. We don't want certain types of buildings next to single family homes. There are safety issues, there are aesthetics issues. And so that's why the zoning code exists, is because we want to create some uniformity. We want to create some fairness for building owners, okay? So the very sort of critical part of this is you don't get to do anything with your property unless the zoning code specifically allows you to do that. Well, what if you really want to do something with this property? What if you're not 100% sure what you can do with this property? There's about 4 or 5 things that you can do. And this is the sort of zoning analysis. If I need a land use change or an exception to the zoning code, if my use is not specifically permitted, or I need an outright change, what are my options? I'm a buyer. I want to come in and change the zoning so that I can do certain things, or I'm on the fence as to whether the zoning code actually allows me to do what it is I'm trying to do. Well, there's about 4 or 5 different approaches. We're going to go over those. The first is the do nothing approach. And plenty of people actually do this. The do nothing approach basically says, I'm going to knock down this building. I'm going to go and put up this, I'm going to do a lot split. I'm going to go in and do these certain things. And if I get caught, well, great. Now I'm going to have to pay back some taxes. I'm going to have to pay back some penalties. I'm going to have to go through the process. I'm going to have to unwind the transaction. But there are many, many people who do it that way. I don't recommend it. Because it's very, very expensive, and ultimately it's usually more expensive. But a lot of people are sort of I'm going to feign ignorance. I'm not going to realize that there's this zoning code that says what I can do, what specifically I can do, and I'm going to do it, and I'm going to ask for forgiveness. I don't recommend that approach. Second thing you can do, you can ask for a zoning interpretation. Okay. For example, in the curbside context, most zoning codes address an accessory use, but they don't do a good job of explaining what that accessory use really means. So in my view, an accessory use is curbside pickup. It's an accessory to the grocery store. It's an accessory to the restaurant. It's something that now people are expecting. And so what you can do is you can request a zoning interpretation, and you're asking the municipality to confirm that this separate use is an accessory use and it's permitted in this zoning area. Okay, it's permitted with this type of structure, and the process usually requires that you have some form of site plan approval or some form of site plan. So it can be expensive, and there's no guarantee. All right, so what you're really asking for is confirmation of what you believe exists, and that's perfectly fine. But most zoning or planning and development folks require that you, number one, have a site plan, and there is no guarantee. Okay, so this is not a guarantee that you're going to get what you want, or that the interpretation is going to be consistent with what you thought it was. And you could be inadvertently shooting yourself in the foot. If you think about it, hey, I'm using this accessory use, I've been using this accessory use, or I've been using this property as a multifamily homes, even though it's designated for single family homes, but I think that I have an exception. I think I've been grandfathered in, or whatever the argument you may be making. You could be inadvertently shooting yourself in the foot by admitting to a zoning code violation, and then you're out of compliance, and then you've got a lot of other issues. So one of the things, the least expensive things you can do is do nothing, like we just said. Second least expensive thing is to request a zoning interpretation. Okay, so we're kind of going from least expensive to most expensive through the process, and we're kind of going through the pitfalls and the benefits. Now, there's a great benefit for that zoning designation interpretation, because you can now take that interpretation and it's binding on the municipality, and you can sell your property and sell it along with that entitlement, because that is a true entitlement. Okay, it's a confirmation letter. All right, third thing you can do, you can ask for a variance or a special use permit. Now, the standards for a variance are different in each county, but they typically require you to show certain elements. Okay, you're basically through going through a variance, you're basically saying to the municipality or whoever it is that you're going before, the Planning and Development Commission, there are special exceptions that apply to my property. I didn't create those special exceptions, a lot size, topography issue, and the variance is necessary to allow me to enjoy reasonable use, reasonable and substantial use of my property. Okay, and so I have to make a pretty big showing there, right? That I am entitled to actually violate the existing code. When you're asking for a variance, you're asking to vary, to deviate, to break the zoning code, to break the law, essentially. And it's special permission that's granted because you've got a weird or unique situation going at your property. And so you're entitled to this because you didn't create that special circumstances or that unique circumstance. A lot of times we see this in connection with setbacks. Hey, I need to be able to have my property go past the setbacks or go over the setbacks. therefore I need a variance to do this. Okay, so that's a common one. I've got a uniquely sized lot. I didn't create the weird shape of the lot, but this is what I need to do on the lot. I need to break or I need to violate, and I need a variance to violate the setback requirements or the building envelope requirements. Okay, so a variance is a tough showing. It can be tough. You have to show that there are special circumstances. You didn't create those special circumstances, and nobody in the immediate vicinity is going to be, harmed detrimentally if you were granted that variance. Okay, and so again, the variances, we see those typically when there are setback issues. All right, so we've gone through the process of sort of, there's zoning interpretations, there's variances, there's the do nothing approach, and then there's also a conditional use permit. Okay, and a use permit is a little bit different than a variance. A use permit is, you are in a situation in which your use is permitted by the zoning code. You're asking for a permit. Your use is actually permitted by the zoning code, but the zoning code has conditions for that use. Okay, so a variance is a complete deviation from the zoning code. You recognize that you're outside of the scope of the zoning code, but you need this variance to deviate. A conditional use permit or a use permit is something that you have to apply for. It's something that's addressed in the zoning code, and it basically is permission to use the property consistent with what the use says in your zoning ordinance. Let me give you a little bit more of an example. The use permit, again, is it allows for something that is already allowed in your zoning code. I'll give you this example. Let's say that you're in a single family housing designation, and there is a use that is consistent with that, which is a church. Okay, the zoning code says that certain churches can be in this area, in this single family designation, in the single family area of town. And a church can be there, but the church must meet certain conditions if they want to continue to be there. Or if you want to put a church there, you have to meet certain traffic conditions. You have to make sure that there isn't a massive amount of traffic, that there's enough stoplights and stop signs, etc. And so what you would do if you're a church is you would say, look, I'm in compliance with the zoning. The zoning code just says I need a permit to do these sorts of things. Okay, so it's quite the opposite of a variance. Variance says, look, I'm in complete, I just can't comply with the zoning code because there's a unique condition. A use permit, on the other hand, is a situation in which your use is permitted, but there are certain conditions that you're going to have to meet in order to continue to use that property as you want to. So hopefully I've done a good enough job to articulate what that really means, and nobody's confused there. But if you are, let me know, and we'll happy to answer that question. Any questions? So again, we have the do nothing approach. I don't recommend it. We have the interpretation approach, which is fairly inexpensive, but can get yourself into trouble. We have the variance, again, which is a tough showing, but it can happen. We have the use permit, which probably not that big of a showing, but you may have conditions associated with your continued use, and that permit is only good for a certain amount of time. And then we have a complete rezoning, a complete rezone of property. And this is the most expensive approach, but if it's approved and you've done it the correct way, it can be extremely valuable for clients. And some clients actually do this during escrow. So what they'll do is they'll go in, they'll buy a piece of property and say, look, so long as I can get these zoning entitlements during the time in which escrow is pending, then I'm going to go through with the deal. If I can't do that, well, then maybe you get to keep some of my earnest money, I get the rest, and we're done with the deal. Okay. But so some people are doing these right now. They're sort of putting them into their contracts that said, I get to try to rezone this. If I can't rezone this, contract's over. Okay. But these can be extremely valuable. There are certain companies out there, and we represent some of them, that all they do is they buy up land or they buy up certain buildings, and the goal is to put in new utilities. The goal is to put in or to obtain entitlements, meaning zoning changes that allow for an expansion of this property. And so There are companies out there whose sole mission is to do this. And what you're doing is you're taking this sort of raw product and giving it a bunch of permission, or giving the ultimate builder a bunch of permission to go in and expand the property. And so zoning changes are extremely valuable, and they're entitlements, they're land entitlements. And so if you find entitled land, you're doing a pretty good job. And if you can get your land entitled, there's no guarantee to it, and it's a very political approach, but it can happen. Now, the steps to obtain a zoning change. Number one, you're going to have to sort of petition to the landowners near you, or the property owners near you, and the municipality itself, that the property and the surrounding areas have changed. There's been a population growth, which we have. There are new amenities that are needed. The utilities are old, or there are no utilities. We need to bring in new utilities. And so you need to analyze what has changed since the time in which that property was designated in its current position, or in its current zoning designation. Okay, so we're looking at the property, step one. We're determining what's changed and what needs to change, step two. We talk with neighbors. We want to make sure that we're notifying them. We have notification obligations. Under most statutes, we have to notify people within a certain radius of the fact that we want to make these changes. And in some instances, there needs to be some negotiation between the neighbors. I've been working on a hotel that's getting revamped into a multifamily apartment complex. And there are neighbors that are concerned about that. And the neighbors' concern are privacy issues. And they want to make sure that none of the people are going to be, none of the people who park at this new multifamily complex are going to be parking on their streets. They want to make sure there's adequate parking. They want to make sure there's adequate privacy. And so some of the negotiation is, well, guess what? We're going to provide all these brand new nice trees for you. And so there needs to be a little bit of back and forth between the current owners and the adjacent property owners as well. And so you want to make sure that you're offering certain concessions, and you want to make sure that you understand what their issues are, so that when it comes down to a planning staff review or an approval by city council or the planning commission, that you've addressed those neighbors' concerns. Because guess what? Those neighbors are going to show up at one of these meetings and articulate their concerns. Okay, so step one, again, we're looking at the property. Step two is we're talking to the neighbors. Step three is you're applying through the required municipality. They're going to require a survey. They're going to require some analysis of what you're trying to do and why you're trying to do it. They want maps, traffic studies, and of course the fee. And they want to see the notification that you give it to the neighbors. Then it goes to a planning sort of committee to give a review and to sort of point out where you've goofed things up or where things could be improved. And that's sort of a process different in each municipality. Then it goes to some sort of planning commission to review it. There's a presentation to this panel. And if it's approved, then the city council or other board that's granted with authority stamps it approved. And now you're on your way to redoing this property. And it's usually a 6 to 12 month process. With the COVID and some of the delays, it's sometimes taking longer. And so if you are somebody, or if you're representing a buyer who says, look, I want to change the zoning, I need to check to see if I can do certain things with this property, you need to budget 6 to 12 months in some instances to do that. Okay, again, I'll note it's a very political process. And you still need to review your CC&Rs if there are any deed restrictions or any other restrictions that affect that title to that property. Okay, so again, there's a couple of approaches when it comes to zoning and land use changes. There's the do nothing approach, there's the interpretation request, there's the variance and use permit process, and then there's the complete rezone, and that's it. Okay. And that's all there really is to land use planning. I don't want to minimize it, but if you break it down into those sort of 5 options, as a buyer or even as a seller, those are the things that you need to know in order to get some zoning approvals and entitlements. And again, those can be extremely, extremely valuable. I'll open it up if anybody has any questions.
One question then. What about medical marijuana? As far as I've got clients now that are looking for buildings and land and so forth. So do they have new specific zoning changes for this as well?
A lot of them do, and a lot of them are working on them. So yeah, those are coming, and there are some zoning designated changes already in place, and the cities and the municipalities are working on more. So it depends on if you want to grow a facility, if you want retail. It depends on really what you want. There are some places that allow it already, but we expect there to be a continued proliferation of rights for people to do that. That is probably the third most popular issue that arises right now. Number one is the housing. Number two is really pandemic related and allowing for those accessory uses. And then the third is the marijuana for sure. And that's probably it's close to being second. And it's to obtain the rights to do what you want to do with that building, including the marijuana, whether it's a dispensary, whether it's, retail, whatever it is. It's getting those entitlements to be allowed to do that. And in some places that exists, hard to find right now. It's hard to find any buildings that are fully entitled there. But it's coming for sure.
Thank you.
You bet. Thank you. I have a memo that I wrote probably 4 or 5 months ago about zoning and marijuana. I don't know if that'd be helpful to anybody. Yeah, in Casa Grande, the Planning and Zoning Department has one online. Yeah, that's right. I'm happy to send out that memo. I also have one on negotiating leases for marijuana related properties, because some people are still nervous about accepting cash and what you can do in those situations. I'd be happy to send those out. I'll put my contact information in the chat, and you can pull it from there if you'd like it, and I'm happy to get you whatever you need.
Patrick,
Perfect.
it looks
Thank
like
you.
there's another question in the chat from Melissa about a cheat sheet somewhere that shows all the different zoning codes.
Do you mean a cheat sheet of the stuff that we talked about, or a cheat sheet of the zoning ordinances? Because the zoning ordinances are online, and you should be able to find those online. If it's City of Phoenix or if it's Pinal County, whoever it is, you should be able to find those online. Now interpreting them is going to take some work, and digging through them might take a little bit of work, and getting used to. Somebody's also asking for a land purchase checklist. I have that as well. So I put my email up there. So if you want that, I'll make sure you get that. But I can send out my sort of zoning cheat sheet that I use. But it's not the zoning ordinance itself is really what you probably are asking about. And those are available online. But the entitlement process is fascinating. If you're good at it, you're literally taking raw product and turning it into something that a builder can use, a home builder, whatever it is, commercial contractor, and then you can seriously make some money in buying raw land, getting it entitled to put in 17 houses, to do a minor lot split, to whatever that may be. And for $10,000 of new, of going through the process, you can increase the value of the property immeasurably. I don't know if there's any other questions, but if anybody needs anything associated with anything that I mentioned, I put out checklists and memos and stuff, and bullet point stuff that might be helpful that you can use yourselves, or forward to your clients and give them a little bit more information as to what they're getting in. Happy to send out the lease one that I mentioned as well, because we're seeing a lot of interesting requests being made of landlords, and it's just a kind of a sign of the times.
Okay, I don't see any more questions. I think we're good.
All right, guys. Well, have a great rest of your week, everybody.
Thank you, Patrick, for all that you do. You're so appreciated.
Absolutely. Take care.
Take care.